Hello, welcome to the Data Privacy Lawyer. It's Funmi speaking, the principal attorney at the law firm. If you like content that talks about data protection and what's happening on a global sphere, and you're interested in how your business can maintain privacy compliance, subscribe to the channel. Today's review, we're going to be looking at some AI terms. Now, the reason we're looking at AI terms is because almost all artificial intelligence, if not all, has implications from a data protection standpoint. Whether it's from a technical perspective, whether it's from a security perspective, whether it's from a processing perspective, all artificial intelligence has implications for privacy, which is why it's really important if your business is considering implementing or integrating any type of artificial intelligence, you need to take a look at what your obligations may be under the data protection laws. Now, this is a very interesting cookie banner. I'm going to I just want to talk about this actually. This is the first time I'm landing on this page. There is no button here for me to accept that cookies are going to be collected, reject that cookies are going to be collected. I'm going to quickly click more information, even though this is a AI review. Oh, that's so interesting. I don't think we're going to be presented with a preference center. That's definitely something that needs to be updated in the future. Okay, so there's no accept all. There's only an X box, right? And then there's a do not sell or share my personal information. And that's the only preference we have. Wow, interesting. So I don't want to go into too much detail because we're doing AI terms here. But we can see here that they use third-party cookies to help them analyze how they use the website, store a person's preferences, and provide the content and advertisements that are relevant to you. But the only button we have is do not sell or share my personal information. We don't have buttons to opt out of these optional cookies, and that is very problematic. So I'm going to save my preferences. We're not going to talk about that anymore. Let's go to the AI terms of use. This was last updated last year, October 2024. Now, generally, my recommendation, especially going into 2026, is that we need to be looking at the representations we make on our sites and review them as and when the business is changing. I would be interested if this organization has not changed at all since October 2024, in addition to how it processes personal data and its AI services. I would be very intrigued if its AI services from this date have remained the same, because most businesses are trying to innovate and grow, and that growth generally has implications for personal data, and as such has implications for data protection laws. The other thing is the data protection laws have changed since this time. So are the representations in this term reflective of those laws? I find it difficult to believe. This Appendix A of the agreement governs a customer's use. I'm interested in who their customer is. Let's see. Okay, so it looks like they have business clients like me, software and tech, education, healthcare. Okay, so it seems like this is a B2B organization. Now, B2B is just business to business. I don't know if they have individuals as consumers. I don't know that, but those are definitely details that I would obtain in my intake form, because I need to be able to understand your business in order to provide you advice. And I talk about this in many reviews that I do. I don't have the full scope of insight on an organization, but I can provide opinions as to what I think based on the provisions that are placed on a public-facing website. Essentially, you're presenting this to your customers. And I don't know if customers are agreeing to this as wrapped into a statement of work, a purchase order, or otherwise. But you're representing to your customers, this is how you use AI. Has that changed since October 2024? That would be my first question. Okay, so if the customer uses AI-enabled features on the services and amends but does not, okay, etc. Let's go down. I want to take a look at the privacy. Okay, let's look at this. Excellent. Before using certain AI services, customers and its authorized users may be required to affirmatively consent to the use of such feature. I am intrigued into which geography the customer is not required to affirmatively consent, because this is very important, right? I am not sure about why the language may be required to affirmatively consent. That being said, not every country actually has explicit comprehensive data protection legislation. So that may be the contingency here. And it may not be eFront's obligations to obtain affirmative consent. And this is true. Even in 2025, there are countries that do not have data protection legislation that is explicit. It's sad, but true. Customer agrees to the extent required by applicable laws that it is responsible for disclosing to its authorized users that their use of the AI service will involve interactions with AI technology, including in some cases AI-enabled chatbots. Now, I want to talk about this. The chatbot is probably the most basic use of artificial intelligence that's in the market. Most organizations do have some form of chatbot, whether that chatbot is on their public-facing website or the chatbot is something internal that they have enabled on a product that they already have. Now, I'm glad that this provision exists, and I'm glad that what's happening here, I just talked about the chatbots, but I really want to talk about this sentence. That is responsible for disclosing to its authorized users that their use of the AI services will involve interactions with AI technologies. Now, what is eFront secretly doing? What they're doing is eFront is placing responsibilities on its customers to ensure that its customers include provisions in their own notices about artificial intelligence. That's what the statement is saying. Now, why is that important? It's important because then the customers are then also responsible for any obligations they have in allowing data to be processed on their end. So eFront is saying to you as a customer, one, you have to affirmatively consent to this feature, okay? Then the customer clicks it, consent. Then the customer now has a responsibility for disclosing it to its authorized users. Let's say, for example, the customer is a business and the business has employees, and the employees are the authorized users that will use the AI services. Now, if the use of eFront's product or service involves personal data, the personnel privacy policy for these employees now needs to state, we may use AI services and we interact with AI technologies and your personal data may be implicated. That's really complex to articulate over a YouTube video, but essentially now the customer has a responsibility to provide notice that AI is being utilized, right? And I love this sentence. I love this sentence. It's excellent. And I think that this has definitely been drafted by a very savvy privacy lawyer. Customer agrees to and is responsible for ensuring that its use of AI services complies with all applicable local, state, provincial, national, federal, and foreign laws. Now, this is really good. I'll tell you why this is good. I'm not sure about the intricacies for eFront's AI services. However, just because you use an AI service that's provided by a vendor or supplier doesn't mean that you don't have any obligations as a customer. In the European Union, now I don't know where eFront is, which is why on my intake form I always ask for geographies where products are provided. But what I wanted to mention about the European Union is there are different categories under the EU AI Act in which a user of AI can be categorized. Each category that you fall under, one, you need to be able to understand which category you fall under when you use an AI tool. But secondly, there are requirements that the EU AI Act has depending on which category you fall into. And again, this sentence puts the responsibility on the customer for ensuring that its use of the AI service complies with that applicable law, if it's in scope. If the customer is in, I don't know, Brazil, they may not have those obligations. If the customer is using the AI services only in Brazil, then again, the EU AI Act may not apply. Now, I say may because there's lots of caveats to the law, which is why it's so important to have a privacy lawyer help you review these nuances. So we didn't get into this one too much. I hope you enjoyed this review. If you're looking for privacy counsel to help you draft any of these terms, take a look at my description below and I will see you in another video.